crowd. Okay, we'll jump right in. We're up to the third chapter of the laws of testimony, and the first two chapters really presents the, at least to some degree, the rigorous questioning that the witnesses, plural, would be subject to in order to ascertain whether or not they're saying the truth. And we talk about even if they contradict each other in significant matters and insignificant matters. So the point of the matter is they have to really get their story straight. Otherwise, the testimony falls away. Now, in chapter 3, we read about a few fascinating distinctions that the rabbis put forth that deviate from the Torah law. In other words, from the original law of the Torah. And it all boils down to the economy, but more importantly, boils down to banking. It all boils down to the availability of credit. We know what happened in 2008 when credit's not available. The whole economy freezes, or worse, or collapses. So the rabbis understood that. And the issue was as follows. The issue is, if you're going to apply the rigors of the questioning of the witnesses that applies to criminal cases, if you're going to apply that to monetary cases, then what's going to happen is nobody is going to loan anybody money, right? If I want to borrow $50 from Jill is going to say, okay, go bring 2 witnesses. I'm going to bring 2 witnesses. 5 years later, when it comes to time to repay, Jill is going to instruct those witnesses to court. The witnesses are going to be subject to a cross-examination, the likes of they have never felt before. And their testimony may not stand up. And Jill loses her $50. What happens next time I need a loan? Next time I need a loan, Jill doesn't give me a loan. So we have a problem. The problem is the more strict you try to be with regard to the implementation, with regard to the acceptance of witnesses, you're trying to get justice, and therefore you're being strict on one end. The problem is that on the other end, what you're going to do is really you're harming the people, not necessarily the wealthy people, but you're harming the people that need the loans the most. And the Talmudic phrase for that is not to lock the doors in the face of the borrowers. I'm a borrower. We don't want the lender to lock the door in the face of the borrower, meaning to reject the borrower and not to lend them money. So the way in order to achieve that goal, you will see this entire chapter is about leniencies in regard to laws of monetary law. In other words, if monetary claims, especially when it comes to loans, we're going to see that the Torah is the Talmud, not the Torah. The Talmud is very lenient, and the Talmud does not apply the same rigor necessary of the witnesses in criminal cases. So that is a big idea. You see the power of the oral Torah, which is to, in some sense, when it comes to the application of the law, they understand, they take other matters into consideration, and they say we're not going to demand the full what's the word I'm looking for? We're not going to demand the full interrogation necessary of witnesses in cases of criminal law. So that's really the overarching theme of the chapter. So if you're into credit markets, this is the chapter for you. Okay, so I'm going to begin to read from Maimonides chapter 3. And in the beginning, he lays out the Torah law. The Torah law is that there is no distinction between monetary law and criminal law. From the Torah's perspective, the same standards of evidence should be required for both. So Maimonides writes as follows: the questioning and interrogation of witnesses is required with regard to cases involving both monetary law and capital punishment. As Leviticus states, you shall have one judgment. One judgment means there is one standard of evidence. There's no 2 standards of evidence depending on what type of case it is. In the United States, there's criminal law and there's civil cases, and the standards of evidence are different. And then you have regular court and you have small claims court. Again, standards of evidence are different. From the Torah's perspective, we're trying to determine the truth. If you want to determine the truth, it doesn't matter if it's a capital punishment case or a case about $50. It doesn't matter. It's the same standards of evidence should be applied, because from the perspective of the Torah, all we want to figure out is the truth, and therefore there's one standard of evidence. However, the sages understand that to apply that would have negative consequences. Nevertheless, our sages ordained that witnesses in cases involving financial law not be questioned or interrogated. And here is the key phrase: lest this prevent loans from being given. And like I said, in Hebrew, the term is not to lock the doors in the face of the borrower. Because if we try to be too strict and we try to implement that we're going to interrogate the witnesses regarding monetary law, then what happens is, what you do is, nobody's going to give any loans. And if no one's going to give any loans, obviously not only the poor are going to suffer, but I think the entire economy is going to freeze, as we have seen just a few years ago. Okay. And then Maimonides spells it out. What is implied? If witnesses say, so-and-so lent so-and-so a mana in this year, a mana is 100 coins, their testimony is allowed to stand even though they did not specify the month or the place in which the mana was given, nor did they say of which coinage the mana was, right? If you remember, when we discussed the first two chapters, there are 7 essential questions. Without these questions, there's no testimony. If somebody says, I think something happened in 2007, it's not a testimony. Why? Because to have testimony, you have to pin down the time and this place, but you have to pin down the time not only to the year, to the month, to the day, but to the hour. You literally have to pin it down to the hour. If one person says 3 o'clock and the other person says 5 o'clock, one witness says 3 o'clock and the other witness says 5 o'clock, the testimony is rejected. And here, when it comes to monetary law, even though biblically speaking, the same standards of evidence and the same standards of testimony should apply, nevertheless, the rabbis say, we're not going to question the witnesses. As long as 2 people show up and say somebody borrowed money in 2015, they're just saying the year. So they're not touching upon all the 7 essential questions. Nevertheless, the testimony stands. And again, if you remember, when it came to capital punishment, we also said you have to know what one of the essential questions, according to Maimonides, is you have to know what was the weapon. And here too, if I say I would borrow money, I would have to say what type of money. Was it US dollars? Was it shekels? Was it silver? Was it gold? What happened? What was the case? But again, over here, because when it comes to monetary law, even though, like I said, biblically, you have to, the same standards apply, but the rabbis say, no, you cannot be strict. If you're strict, you're going to harm, first of all, you're going to harm the economy, and especially you're going to harm the poor people. So that's the big idea in section 1. And then we're going to start explaining and elaborating, but this is a big idea. And the reason why it's so fascinating is because you see here that the rabbis have a certain leeway that they can apply, and they could adjust the law within the confines of the law to make allowances to allow for the economy to flow. How could the rabbis change the Torah? That's a very good question. So one way to think about it is that when it comes to monetary law, the court and the government, but in this case it's the court operating as on behalf of the people, they have the right to create economic policy. So they have the right of taxation. And one form of taxation is saying, even if by the dry letter of the law, you don't have to pay, but we feel under these standards, the policy is you have to pay. So that's what's happening here is. We're not saying that we believe for sure that this event happened. We're just saying for economic policy, in order to allow the economy to flow, this is the rules the people have to, the people sort of feel is the right way to move forward and to allow for the economic progress. That is, so it's not changing the Torah. It's just giving. It's sort of where the people have the right to create certain economic policies. So that is, again, the rabbis are not saying the Torah says this. They're saying, no, the Torah says indeed you're not obligated to pay, but society has the ability, has the right to say that in such cases, somebody will pay. We impose this policy that somebody would have to pay, even though the standards of evidence have not been met fully. So that's the big idea. If anybody wants to comment on the big idea, like they say in Russian, I think, Ajalista. Otherwise, we continue and elaborate and talk about which cases and some of the details.
So, Rabbi, the big idea is effectively we're giving some protections to the lender to facilitate lending.
Correct.
So that they will continue to supply capital where needed.
Correct. Now, this is not popular always. If you move out of Greenwich, it's not popular because people like to hate the lenders. It's very popular to hate the lenders, right? Today, you hate the lender, you become a celebrity. The problem is, if you make it too difficult for the lender, what happens? The lender is not hurt, the borrower is hurt. And that's what the sages understood. If you're going to make it too difficult for the lender to collect the loan, no one's going to lend. Now, I'm not going to say that everything that happens on Wall Street today is kosher. So for example, the Torah has very strong protections for somebody that cannot pay, and how to protect that person's dignity. And certainly in those days, there were up to very recently, there were debt prisons for people who can't pay back. And the Torah really protects the right of the borrower who cannot pay. And interesting, we'll go into that another time. There's no bankruptcy, but we do protect the right. And a lot of the aggressive collections tactics used today would be outright prohibited in the Torah. So the Torah tries to strike a balance between the need of the borrower and the need of the lender. But here is a classic case. We're making it too difficult for the borrower.
It really looks as if, for the sake of being, I guess, we're breaking up.
Okay. I hear you. If you want to talk, I think we still hear you, so you can go ahead.
I keep breaking up. Okay, it just seems that for the purpose of continuing the livelihood of people, commerce, you have a lower standard of justice, because justice would require you to be specific.
Correct.
Okay,
Correct.
so we are now balancing justice with the consequences of applying justice.
Correct. The Torah is in the business of justice. And the Torah says, theoretically speaking, how do you know what's just? You need two witnesses. That's the burden of evidence. The rabbis say there's a value for justice, but there's also a value of economics. Not just economics, I would say even more. There's a value of helping the poor. How do you help the poor? By allowing the lender to collect. Because if you don't allow the lender to collect, the lender is not going to make a loan next time. But you're absolutely right. This Torah is addressing the standard of justice, of truth. And the sages are saying that's a very important concept, but you also have to think about the application of what are the real world consequences. And when it comes to economic policy, the sages have the authority to introduce economic policy. And the economic policy that they are introducing is that they're going to lower the standards of evidence when it comes to collecting debt.
Rabbi?
Yes.
Is there a simpler way to kind of enforce the law in a monetary case by issuing a document?
Document is another story.
In this case, you don't need the witnesses. That's why the witnesses are not so relevant.
Vicky, documents are a fascinating invention. It's a very good economic tool. We're going to discuss it in section 4 of today. We're at section 1. We'll get to section 4. And documents are problematic in their own right. They create the whole concept of the fact that you can use a document is a leniency, as we will discuss. So we're going to discuss documents, but documents are also complicated. In other words, we'll get to the documents. The documents doesn't solve all our problems. It solves some of them, but not all of them. Okay, so what I really want to go ahead. Okay, what I really want to try to do now is I want to try to read quickly to number 4, because number 4 is where it gets interesting again about the documents, but I'm going to read 2 and 3 just so we get the full chapter. So I'm going to just read fairly quickly. If you have any questions, you could stop me. When does the above apply with regard to admissions of liability, loans, presents, sales, and the like? Cases involving fines, by contrast, require the full process of questioning and interrogation. Needless to say, this applies with regard to cases involving the penalties of lashes and exile. Similarly, okay, so that's the first point. The first point is that when we say that the burden of evidence is lowered, it's only for monetary cases, but it's not for other forms of criminal cases where the penalty would be a fine or lashes or exile. In the biblical law, if somebody killed someone by mistake, they would go to exile to one of the six cities of refuge. In any case, in other words, we're just referring to the cases of monetary law. However, the second half of 2 is actually interesting. The judge does have some discretion. So if the judge feels that this case is questionable, then he is allowed to keep questioning the witnesses of monetary law. In other words, we're giving the judge some leeway. What we're saying is you don't have to disqualify the loan because you don't have proper witnesses. But if you feel, Mr. Judge, if you feel that there's something here, the shenanigans, something here is not, someone here is not honest, then you have the right as a judge to question the witnesses. Similarly, if a judge perceives that a claim may be contrived and his suspicions are aroused, questioning and interrogation is necessary, even with regard to cases involving financial law. Now, the commentaries explain, even so, the judge does not have the right to impose the same level of interrogation as when it comes to as biblical law, as when it comes to capital cases. In other words, even if there's a slight contradiction or one person doesn't know, it doesn't mean the judge could throw out the witnesses, but it does mean the judge should question if he feels that there's something here that is questionable. Okay, I want to read 3 because I want to get to 4. Okay, if we go back, if you just remember what happened in the first two sections, we differentiated between the essential questions and the non-essential questions. The essential questions were basically the time and place and what was the weapon. And the non-essential questions is everything else. And when it comes to the biblical law, when it comes to the essential questions, they both must give an answer and the answer must be consistent. When it comes to the non-essential questions, one or two or both could say they don't know, but they can't contradict each other. And now we're going to try to think about how does this apply to the laws of monetary, to the witnesses of monetary law. If they contradict each other or they don't know, what happens to their testimony? So that's what 3 is here to spell out. Although there is no requirement to subject witnesses in cases involving monetary law to the full process of questioning and interrogation, if the witnesses contradict each other with regard to the Rishot and Chakirot, which is the essential questions, their testimony is nullified. If the witnesses contradict each other with regard to the Bedikot, their testimony is allowed to stand. So, and he's going to explain, but it's in simple English, I'll explain. Let's say Jill brings 2 witnesses to court, and she says that I, Menachem, owe her $50. And we know that we're not supposed to contradict the witnesses, but we're not supposed to interrogate the witnesses, but we have to listen to the witnesses. So witness 1 says, Menachem borrowed from Jill $50 in 2014. And witness 2 says, Menachem borrowed $50 from Jill in 2015. They're a year off. So they contradicted each other with an essential point. In that case, even in monetary law, the testimony does not stand because they contradicted each other in a critical question. If, however, the witnesses contradict each other in a non-essential manner. So, for example, they say, what car was I driving when I came to borrow money? And one person says I was driving a Toyota, and the other person says I was driving a Ferrari. right? Well, I wasn't driving a Ferrari, but that's what the person said. So even though there was a contradiction, nevertheless, because this line of questioning is not essential and it's monetary law, the testimony stands. Again, because of the lower standard necessary for the questioning of monetary witnesses, the purpose of which, of course, is not necessarily to help the rich, but it's to help the poor. It's to help the poor who need loans, but also to help the entire economy who needs capital. Because if capital freezes, you end up, everybody suffers, as we said. Okay, so now, what is implied? The second paragraph of 3, this will spell it out. What is implied? One witness says he borrowed from him in Nisan, which is the first of the Hebrew months. And the other witness says, no, he borrowed it in Iyar. So they're questioning, they're contradicting each other about the month where the loan took place. Their testimony is nullified. Or one says the loan was given in Jerusalem, and the second says, no, we were on Lod. Their testimony is nullified. Again, why? Because they're contradicting each other in regards to an essential question. Similarly, if one says he lent him a barrel of wine and the other says it contained oil, the testimony is nullified, for they contradicted themselves with regard to fundamental questions. If, by contrast, one said he lent him a black manna, while the other said it was a white manna, so the color of the coin, okay, the color of the coin is not essential. So even though they contradicted each other in a non-essential, even though they contradicted each other, because it's a non-essential point, the testimony stands. Because it's monetary law, not a capital case. One says they were in the upper story when he made the loan, and the other said they were in the lower story. Their testimony is allowed to stand. Moreover, even if one said he lent him a mana and the other he lent him 200s, the defendant is obligated to pay him at least a mana because 200 contains 100. This is fascinating, right? Jill has 2 witnesses. One witness says I owe her 100. The other witness says I owe her 200. So you can argue the witnesses didn't even get their story right. So throw out the testimony. Well, that's what we would have done from the Torah law perspective. But from the perspective of the rabbis say no. The rabbis say we're not going to be so rigorous. And because both witnesses agree at least about 100, so they'll say I have to pay Jill 100. If one said he owes him the cost of a barrel of wine and the other says a barrel of oil, the defendant is required to pay the lesser amount of the two. Similar concepts apply in all analogous situations. So in short, without spelling out every case, in short, what's happening here is when it comes to a case of monetary law, the witnesses do not have to be questioned. They do have to, of course, offer testimony. And if they contradict each other in regards to an essential question, as we defined essential question in the last 2 weeks, if they contradict each other in an essential question, which is time and place and the actual event, then the testimony is nullified. If, however, they contradict each other in a non-essential question, did it happen on the first story of the house or the second story of the house? Did it happen in the dining room or the living room? It doesn't really matter. So in that case, even though from the Torah's perspective, a testimony should be nullified, but from the perspective of the rabbis, the testimony is allowed to stand. Again, we don't want to lock the door in the face of the borrowers. And here, ladies and gentlemen, we get to the big idea, the second big idea that we're going to have in this chapter, and that is the introduction of documents. What does a document do? When could it work? And I'm just going to give you a preview. Okay, well, no previews. If anybody has any questions, wonderful. Otherwise, we go straight into the concept of a document. Okay, everything makes sense. That's the beauty of Maimonides. Maimonides writes in a clear fashion, straightforward fashion. It's beautiful. Everyone understands. This is why we study Maimonides. Okay, let's talk about documents. Vicky said that documents are a very good idea. Why does Vicky say that documents are a good idea? Because she says you don't have to question the witnesses. Everything is written down, the time, the place, the events, everything is fine. The witnesses sign sign their names, and everything is straightforward. There's no questions. Everything is fine. That is the argument pro documents. What is the problem with the document? So if anybody wants to jump in, if you read or you guessed, what's the problem with the document? There's an essential problem with the document.
It can be forged.
Go ahead, Andy. I'm sorry?
It can be forged.
It could be forged. But even before that, let's say it's a genuine document. You're right. It could be forged. Correct.
It could be lost.
It could be lost. But what is essential? You have Jill shows up in court with a document. There are two witnesses that sign that say that I owe her $50. What's the problem with this? Forget about if it's forged. Even if it's correct, what's the problem with it, with which accepting of a document? The problem is that from the Torah's perspective, witnesses have to show up and testify so they can be cross-examined, right? You can't come in testimony and say hearsay. I think someone told me that this is the case. Someone wrote that this is the case. If you're going to make a testimony, if you're going to testify, you have to show up and say the claim and subject yourself to cross-examination. Think about a criminal case. Would you prosecute from the Torah's perspective? I don't know about this country, but in the Torah's perspective, if two people sign an affidavit and say, we saw that guy killed someone else, and they send the affidavit to court, would the court accept it? Of course not. Because if there's witnesses, for a witness to be considered a witness, he has to show up, he has to face the accused, and he has to testify, and he has to subject himself to cross-examination. So here's another point. From the perspective of the Torah, witness testimony, affidavits are a waste of time. They're not considered testimony. They cannot be accepted. Yet, just like we said earlier, and that's why it's in the same chapter, the rabbis instituted that we will accept witnesses when we've accepted documents when it comes to monetary law. Why? Otherwise, no one's going to loan money. Because again, Jill wants to make a loan to me for $50. If she has to find witnesses, and the witnesses then will travel to Australia, and then if she wants to collect the money, she has to fly in the witnesses from Australia. It's too complicated. So Jill is not going to want to loan me money. So the rabbi said, you know what? Instead of a testimony, we'll accept a document. And the beauty of a document is, like Vicky says, the beauty of the document is that the witnesses can sign it, and then they could leave, and Jill doesn't have to worry about with the witnesses. She just has to worry about the documents. So that's the big idea. Now, Andy is 100% correct that the question of how do you ascertain the authenticity of the document is a very important question. And Talmud spends a lot of time trying to figure out how do you figure out which document is forged and what's not forged. So that's a whole nother problem, a technical problem of how do you validate a document? How do you authenticate a document? But even before we get to that question, the question becomes, from the Torah's perspective, we have a more of a fundamental question, because from the Torah's perspective, a document is not testimony. You want to testify, show up in court, say the testimony, subjugate yourself to cross-examination. You can't cross-examine a document. So therefore, from the Torah's perspective, when it comes to all matters of law from the Torah's perspective, a document is worthless. But again, the rabbis saw that if they stick to what Jill called truth, if we stick to truth, there'll be no economy. If we stick to truth, there'll be no loans made. Therefore, the rabbis say, ladies and gentlemen, we're making a new economic policy, and that is we are allowing the acceptance of the introduction of documents in cases of monetary law. So far we have two big ideas. One big idea is we're not going to question witnesses when they show up. We're not going to question. We're not going to interrogate witnesses when they show up to testify about monetary law. We don't want to scare away the lender. That's one allowance allowed. That's one allowance for the monetary law where we lower the standards. And the second big step that we do to allow for the capital to flow is that we allow for the introduction of documents as evidence, even though from the Torah's perspective, documents are not a proper form of evidence. Now, what I just told you right now is Maimonides. Other people disagree. Other people feel that the Torah would allow for documents. In other words, Torah does feel documents are legitimate, but that's beyond the scope of studying Maimonides. From Maimonides' perspective, Maimonides believes, as the Torah says, by the mouth of two witnesses, al pi shnayim eidim, the verse is by the mouth of two witnesses. And the Talmud says, by the mouth, but not by their writing. Right? The verse says, al pi shnayim eidim, by the mouth of two witnesses, a matter should be established. So that's by the mouth, not by the writing. Others disagree. The others say that it's coming to tell you that the verse only means someone has to be able to talk. But once they're able to talk, they're not mute. If they're able to talk, then they could write, But again, that's beyond the scope. Maimonides reads the Talmud simply, "Mipiem v'lo mipik savam." You can accept testimony from their mouth, not from their writing. And therefore, Maimonides says, biblically speaking, documents have no validity whatsoever, and it's only the rabbis who allow for the acceptance of documents in order to allow for loans to take place and capital to flow and society to flourish. So that's big idea number 2.
Rabbi, is it a good time for a question?
Excellent time. I'm waiting for questions.
So let's say there's a document that says something, and then one of the parties says, yes, but we agreed later that portion of the document would be changed or wouldn't be operative. And so
Okay.
you have in that case, what would Maimonides say? Would the document control, even though there's now a person who's testifying that the document didn't faithfully reflect the terms of the transaction as ultimately agreed?
Okay, I can tell you went to law school. The good news is, the short answer is that Maimonides addresses it in number 5. This chapter number 5. I don't know if I thought I was going to get to it today, but we'll see. If we don't get to it today, we'll get to it next week. Yes, the big question is, once the document is introduced, how much are even the witnesses who testified on the document, right? A document is signed by 2 witnesses. So let's say there's a document and Mr. A and Mr. B signed the document. Now Mr. A and Mr. B show up and they say, well, there were conditions. Well, there were stipulations that were not written in the document. The question is the document subject to the interpretation of the witnesses who signed the document, or does the document stand alone? And like all good Talmudic questions, Warren, the answer is it depends. But the good news is that it's all spelled out. It's all spelled out in number 5 and on.
Rabbi, I have a question.
Yes.
What's the importance of precedent in making these decisions?
Well, precedent is important, but precedent is important, but more than I don't know if precedent is something in itself. Precedent is not that important. I mean, I wouldn't consider myself a Talmudic scholar, but I would consider myself a Talmudic student. Precedent is not that important. In other words, if a later court feels that the lower court, that the previous generations are mistaken, they have the authority to make change. Then there are cases of precedent that cannot be changed. So that's so that's a subject for itself. In general, it's not. How do I answer that? Precedent precedent in general is not that important. There are certain cases of laws that have been laid down and accepted by the people that if you want to undo those laws, you need to have we meet certain requirements. Do you see what I'm saying?
Okay, thank you, Rabbi.
Rabbi,
Yes.
is will considered a form of a document according to Maimonides, or as a separate category?
It's a form of a document, and it's a form of monetary law. And therefore, Maimonides would say that witnesses on a will are accepted. Maimonides believes that from the Torah's perspective, you can. It's not about the will, the written will. It's about the 2 witnesses who are testifying to the words of the person of what he or she wants to happen to his estate. In other words, Maimonides believes the Torah also allows for people to be able to transfer their wealth or make any gift or whatever they want based on testimony. The question is, does the testimony have to be witnesses that can be questioned, or is it testimony that can be written down and then the witnesses could travel to a different country? So again, Maimonides believes that from the Torah's perspective, for every matter you need witnesses, and the rabbis said that documents work. Other people feel that even from the Torah's perspective, documents are more accepted, but that's, again, beyond the scope of the class here. Okay, so I'm going to read Yeah, I'm going to read number 4, and that's the introduction of the big idea. And then if we have time, we'll go to 5, 6, 7, the whole rest of the chapter, which is really Warren's questions about how independent does the document stand? If the witnesses who signed the document want to contradict or amend or change or add to the document, do they have the authority to do so once the document has been introduced? Fascinating discussion. We'll get to that. If not today, then God willing, next week in good health. But for now, let's read number 4. Din Torah. Let's read it in English. According to scriptural law, we do not accept testimony, neither in cases involving financial matter, nor in cases involving capital punishment, except orally from the witnesses. In other words, the witnesses have to show up and have to speak, as implied by Deuteronomy 17:6, on the basis of 2 witnesses. This is a bad translation. Of course, it's English. You can't get it precise. The precise words in Hebrew is al pi. Al pi could mean on the basis, but literally al pi means by the mouth. So the verse is saying, by the mouth of 2 witnesses, a matter should be established. So the rabbis say, what does that mean? That means implied is that testimony is accepted only orally and not on the basis of their written statements. Again, you cannot run an economy like that, obviously. According to rabbinic law, however, we decide cases involving financial matters on the basis of testimony recorded in a legal document, even if the witnesses are no longer alive. This measure was enacted lest the alternative prevent loans from being given. Same point. In the Hebrew, it's the same concept. Not to lock the doors in the face of the borrowers. That's a Talmudic phrase. It's good to get the flavor of a Talmudic expressions. You don't want to lock the door in the face of the borrowers, and therefore you have to lower the standards to allow for the lender to collect.
Rabbi, how much of this study of law informs us today?
Well, this concept is very much irrelevant. In other words, the concept that testimony, that witnesses work in rabbinic courts, the concept that documents work, that applies to rabbinic law, rabbinic courts as well. In other words, this is the fundamental question of, could you prove something based on a document? And the answer is, biblically speaking, no, because documents have problems. Their main problem is that the person who signed the document cannot be cross-examined. The person who signed the document is either Australia or dead. But yet the Torah believes, therefore the Torah believes that documents are problematic. And here we say no. The rabbis say that is if you're looking for truth. But if you're looking to run an economy and you're looking to allow for loans to be given, you have to make a policy. That again, the rabbis have the power as the representatives of the people. The people have the power to say, we're going to create financial policy, and the financial policy is going to say that we accept documents. So this absolutely informs us today, even in the modern era, when people go to rabbinic court to settle their disputes. But this is a fundamental question. It's fascinating to consider what the world would look like if there would be no documents. Remember, everybody's living in a small shtetl. No one travels. You've lived in the same town for 1,000 years, unless you were expelled. But in any case, everyone knew everybody. Everyone had the, you say, oh, well, who testified for the sale of this home? Oh, it was Yankel and Shmerel. We know those 2 people. But again, you can't run so it's the system. That system is preferable in the sense that you can call them in and question them, which you cannot do to a document. So you get more truth. You get more truth, but you get no economy. So it's really a question of balancing interests of truth versus, peace, or truth versus loans, or truth versus capital. Okay, so let's finish the piece here so we can get to the question of 5, which is what happens if once the document is introduced, could the witnesses who sign the document, could they start amending the content of the document? And of course, the answer to that is it depends. Okay. So I'm reading the last 3 lines of number 4. We do not adjudicate cases involving fines on the basis of testimony recorded in a legal document. Needless to say, cases involving lashes or exile are decided only on the basis of verbal testimony, not on the basis of a written document. If any lawyers on the I guess, I don't know if this is a valid question, but I guess you cannot create an affidavit and sign that you saw a crime, at least in the Torah, even according to Maimonides. I'm not sure what the law would say here in the common law or in American law, I don't know. But if you have affidavits signing on criminal cases. Anybody help me out, please?
Well, it's hearsay. I mean,
Hearsay. Hearsay is not accepted.
but there are all kinds of exceptions. But as Maimonides would say, or the Talmud would say, it depends.
It depends, yeah. But in principle, hearsay is not accepted, and affidavit is hearsay. Okay, thank you for that. So in that case, we're on the same page. But again, so that stands even according to once the rabbis allow for documents, that's in monetary law, not in capital punishment, not criminal cases, and not cases where there's a fine or lashes or punishment, meaning not strictly monetary cases. Okay, now the only question is 1043, whether or not we should start and go into the next section and get into cases of.
I'm working out from 11 to 12, and we'll leave. Yes, we could leave a little early.
Cases of monetary law.
And you could show her Gringo. Hi, Gwenny. Dylan, do you want waffles?
Oops.
Do you want waffles?
Or we should stop here.
I don't want.
Let's see if we can do 5. Okay, we'll start with 5. Five, in short, I just want to get people a feeling of what's going to happen here. The short answer we say is once the document is signed and the document is introduced, people cannot change. And after 5, we get 6, and we get all sorts of exceptions. But the big rule is, in other words, the principle of law is, because the document is self-standing, once you accept the fact that a document is testimony, therefore, the general rule is witnesses cannot amend what they said on the document. Of course, it's a general rule. The chapter continues and it goes and it has 12 sections. And of course, there are other laws, so there's going to be exceptions. But I want to introduce the big idea. And next week, if we come around next week, we'll go more into the details, which are fascinating because they touch upon fundamental questions. So let's read 5. In both cases involving financial, and I'm sorry, made a mistake. The question of Warren's question of could the witnesses who signed on the document change their mind or not, that we're going to address next week because that is 6. 5 is even more fundamental. 5 is what happens if witnesses show up and testify, and then tomorrow they want to come back and they want to amend their testimony. So forget about the documents. The documents is next week. Even if you have witnesses. So witnesses show up, they testify in court today on Monday. What's today? Tuesday. Today on Tuesday. Tomorrow, Wednesday, they show up and say, oh yeah, we meant so-and-so. They want to amend, they want to change, they want to add. So do they have the authority to do so? So the principle is no. Of course, there are exceptions. So let's read 5. In both cases involving financial matters and cases involving capital punishment, once a witness has testified and has been questioned in court, he cannot retract. In other words, of course, the witness comes. We question. Once we question him, he cannot retract. What is implied? If the witness states, I testified in error. Right? They come back tomorrow. Today, witnesses testify, and we interrogate them, and their testimony stands up. Tomorrow, they show up and say, "Oh, I'm sorry, we lied." So, could they undo their testimony? The answer is they cannot. Because once you testify and testimony is accepted, you can't retract. What is implied? If the witness states, I testified in error, I inadvertently forgot the details and now remember that it was not so, or I testified only out of fear of him, we do not heed him. We don't listen to the witnesses. We don't give them the ability to amend what they said, even if he provides an explanation for his statements. Similarly, he cannot add that any of the matters he mentioned in his testimony were conditional. You can't show up the next day and say, oh, remember I told you yesterday that Yankel owes Jill $100. Well, today I'm adding, and that's only on condition that Jill joins the SpaceX and goes to the moon. You can't add that. You can't show up and add conditions. The general principle is any statement made by witnesses after his testimony was delivered and questioned that will lead to the nullification of that testimony or that adds a condition to the point stated is not heeded. So when it comes to witnesses, once the witnesses come and the witnesses are questioned, they cannot retract, they cannot add, they cannot add a condition. What becomes interesting is with documents, because documents are not as powerful as witnesses to begin with, Therefore, there's a little bit more leeway where the witnesses could add and change. But witnesses, because witnesses' testimony is considered completely solid and absolute, so once it was accepted, it cannot be amended. But the testimony of witnesses, the testimony of a document, in general, the same rules apply. You can't change, but there are cases where they could change. And the reason is because it's not that strong to begin with, therefore you could amend it. The testimony of witnesses, by contrast, is absolute, and because it's absolute, they cannot add, they cannot change, and they cannot add conditions. So I hope you enjoyed it as much as I did. This is fun, a little different than what we study with the more philosophical areas. This is dry law, good stuff. If you like it, you love it, and therefore I appreciate you joining. The programming for this week, tomorrow we're going to do a section of the Rebbe's teachings because tomorrow night is the Rebbe's 26th yard site. Thursday, as usual, Parsha. Friday, as usual, Parsha. Next week, because we did the book of Jonah, because we did the book of Ruth, the book of Jonah, I'm considering doing the book of Song of Songs because I never really studied it the way I should have. It's the great love story that's included in the Bible. No one knows why it's included in the Bible. Well, maybe it's because it's the love story between God and the Jewish people. It's rich in literature, rich in metaphor, rich in inspiration. So maybe we will do that, God willing. God willing, we'll do that next Wednesday, and throughout the Wednesdays, throughout the summer, there are 8 chapters, enough to keep us busy, at least until the next 8 weeks. Okay, that's the story in short. I really appreciate everybody joining. If anybody wants to ask any questions, now is the time.